Hello, my name is Doug Pinkham with Pinkham & Associates. We are a dedicated family law firm in Orange County, California. This video is instructions on how to work with the FL 300. This is the request for orders. This is the form that you're going to use if you're asking for child support. It's the form you're going to use if you're asking for custody orders. It's the form you're going to use if you're asking for visitation orders. It's the order you're going to use if you're asking for spousal support or attorney's fees or even special holiday visits. It's the form you'll use if you want to go to court to ask for specific transportation orders with regard to visitations and custody. A request for order is the magical form that you're going to use to ask the court for almost any orders at the family court. All right, folks, so I'm going to start at the top, and I'm going to make this video pretty generic. So if you're going to court and you want to ask for child support, I'm going to show you on this form how to ask for child support. If you're asking for child support and custody and visitation orders, I'm going to show you how to do that too. If you're only asking for attorney's fees, I'm going to show you how to do that with this form. If you're only asking for spousal support, I'm going to show you how to do that on this form. Okay, folks, so let's start at the top. And by the way, some of you can see the form and we're working directly on it. That's fantastic. Those of you that cannot see the form, there's a link below. Click it. I recommend that you pause this video right now, download that video or that form, print it out so you've got it right in front of you, because I'm going to go line by line through this video. I mean, line by line through the form to help you figure it out in this video. All right, folks, go ahead and do that now. Pause it and then come back if you need to download that form. Otherwise, I'm going to move straight on to the form. All right, folks, starting at the top. Again, this is the FL 300. Starting at the top is your name, your address. It says firm name there. Just ignore that if you're filling out your own paperwork. That's the firm name of a law firm if you've hired somebody. If you're doing it on your own, you just ignore that line. Then you put the city, state, and zip code of your address. Then you must have your phone number in there. If you have a fax machine, you can put a fax number in there. You need not if you don't have one. You can also put in your email address, but it's not absolutely necessary. Attorney for, you can put your own name in there and then put in propria persona or improper, in, next word, P-R-O, third word, P-E-R. Improper. It just means impropria personam, which means you're representing yourself in Latin. It's a standard term that we use in the legal field. So next line is the Superior Court of California, County of. And if you're in the Tulare County, put it in there. Los Angeles, put it in there. Orange, put it in there. Riverside, put it in there. Whatever county you're in, whatever county you're filing your paperwork in, put that in there. Then the next line is the street and mailing address of the court. If you don't know the street or mailing address, by the way, it's on the other forms in your divorce case or your paternity case or whatever case you're involved in, legal separation. It's on those forms, but you can also Google it real easy. So get the court address for the family court that you're filing your paperwork in, and then it asks for the branch name. You're also going to probably need to get that online unless you happen to know it. It might be just Central. It might be the East District. They have one of those in Los Angeles. It might be the Lamoureux Justice Center if it's in Orange County. But look at that. Look that up and put that name in there. Next line is for the petitioner. The petitioner's name is always the petitioner's name, as you probably know by now. So if you were the petitioner when you filed the original case, you're still the petitioner. You're always going to be the petitioner. If you were the responding party, if you were the respondent in the original case, you're always going to be the respondent. So put the appropriate name on the appropriate line there. And don't worry about other parent or party, because if you're filling this out for a request for a child support or something, that's not going to apply. Then the next section asks for, it's a request for orders for temporary orders, like you just filed a divorce case or you just filed a paternity action and you're filing this to get temporary orders for child support or custody visitation, whatever they are, before you get to trial. You want temporary orders to go into place, for example, to pay you child support until you get to trial. You don't want to wait 6 months, 8 months, or God knows sometimes a couple of years to get to trial that whole time with no child support. So that's what this is. This is temporary orders until you get permanent orders at trial. If that's what you're doing, mark temporary orders. If there are already current orders with regard to custody or visitation or child support, spousal support, whatever it is, and you're filing this paperwork to change those old orders to new orders, raise your child support, raise the spousal support, ask for attorney's fees, or lower the child support, spousal support, and you're asking to change the orders, then you'll mark change. If it's neither, it's probably going to be temporary orders. You can put temporary orders there. If it's, like I said, if it falls into that category where I was describing before trial, mark temporary orders. Okay. And again, if you're changing present orders, mark change. All right. And then the next sections, you're going to mark the boxes, potentially, that apply to what you're asking for. If you are asking for child support or child custody, then you'll mark the custody box. If you're asking for child support, you're going to mark the child support box. If you're asking for visitation orders, then you're going to want to mark that box. If you are asking for a domestic violence order, you'd mark that box. And spousal support or partner support. So I'm going to do this form with multiple things so that you can get an idea of what it's for. Let me go further. So if you're asking for specific orders to the court so that you can get, for example, the use of a cell phone that you've always used but is in your spouse's name or your girlfriend's name or something, then you would mark property control because then you're going to be asking for that order. If it's something different, by the way, and off to the right, here's an attorney's fees. If you're asking for attorney's fees, that's fine. Little warning on attorney's fees. There's a lot of different stuff that's required for you to reach the threshold level of completing, of getting the documentation needed for the request for attorney's fees to even be valid at court. So that's going to be a separate section in its own. Asking for attorney's fees is a big deal these days. It used to be pretty straightforward, but somebody complained and somebody brought a case up the court chain of command, and some case law came back down where they are really cracking down on those items that are required to ask for attorney's fees. So just be careful with that. It's not just fill this paperwork out, submit it with an income and expense declaration, and expect the judge to do it. It's, there's an FL 157 required. Anyway, I don't want to get into it all, but it's a big deal these days. So I'm going to get rid of the attorney's fees and costs. Okay, so other. Let me talk about other for a second. The other box might be, I don't know. You might be asking for emergency orders to keep your child from leaving the state of California. Who knows? You might have had just gotten an argument with your wife or your spouse, your husband, or the mother of your child or something, or the father of your child, and the other parent has said, to heck with you, I'm picking the kids up and I'm moving to Michigan to live with my parents. And I'm going this weekend or next weekend or whatever. You would want to file and mark the box other, and off to the right, you might put in that box, other, keep children in California, or something quite simple like that. There's another line right below that where you can continue to write further. something to that effect. If that's what you're asking, then that's what you're going to mark. All right. And then later on this form, there's going to be a place to expand on your requests, whatever you're marking in these boxes. But let's say we're, at the beginning of divorce, and standard stuff, we're going to ask for, child custody, visitation, child support, property control, because we'll ask for the use of the car that you always drive and the cell phone that you always use that's in your spouse's name, and some spousal support. You're going to ask for spousal support. All right. So then, and then over to the right here, you need to put your case number in there. The case number never changes, so it's the original case number that you have. Put that there. All right. Then let's go down the form a little bit. All right. So this next line, number 1, 2, and it says name or names. That box is for the other party in your case. So you're saying this is to, John Doe or Jane Doe, whoever the other party is. If they're represented by counsel, you're going to want to put Jane Doe and her attorney of record, or John Doe and his attorney of record. Okay? And you're going to want to mark the box below of who that person is. So let's say, for example, you are the petitioner, then the other party would be the respondent. If you're the respondent, then the other party would be the petitioner. So whoever they are, mark the appropriate box. All right? And then you're not going to mark anything under number 2 because you don't know when the court date is going to be until you file the paperwork. So the clerk will write that time and date in there in the department number. So then you go down to court order. If you are asking for immediate orders, you can fill in some information down there. I recommend if you're just bringing a regular noticed request for orders. So that means if you're walking into, you're going to file this and you're going to serve the other party in an appropriate amount of time, and you're going to wait for a normal court date 5, 6, 7 weeks out, you don't need to put anything in this whole section. You just move, and that's what I'm putting this together. I'm not giving you information on or telling you how to fill out an emergency order. That would be a separate set of videos because that's handled differently. So this is just standard information if you're going in to ask for, standard orders, custody, visitation, whatever it is. All right, let's move on to page 2. Again, at the top, that is petitioner's name, respondent's name, and case number off to the right. Then we are going to move on to number 1. Now, what we're going to do here is we're going to mark the box with an X in front of those boxes that apply. So if you're asking for restraining order information or a restraining order stuff, anything to do with a restraining order, you're going to mark 1. That's probably not the case because this is not a place to ask for a restraining order, but if you want to give the court notice that there's an existing restraining order, this is the box, this is the section to do that in. So you'll see it says 1 or more domestic violence restraining orders or protective orders are now in effect between, and then you're going to say petitioner, respondent, petitioner, whatever. And so you're going to mark this box if there exists a present restraining order. You want the court to know that as they read the rest of the form. So for example, if you're asking for custody or visitation orders, it's highly relevant if there's a restraining order in effect. If you're asking for spousal support or fighting a spousal support request, this wouldn't be the form to do that. But if you're asking for spousal support, it's very important to know if there's a restraining order in effect. Okay, so put that appropriate information in that section. Then we go on to number 2. If you are asking for custody orders, and you're asking for temporary orders before trial, so it's after the divorce was filed or after a paternity was filed or after a legal separation is filed, and you want to get temporary orders with regard to custody of children that will be in place all the way until you get to trial, then you're going to mark that I request temporary emergency order. Oh, I'm sorry. That's for emergency orders. That's it. That's the other video I was talking about. So don't mark that box unless it's for an emergency, but I'm not giving you information on that. So don't mark that box with regard to what I'm telling you in this video. But if you're asking for custody orders, mark child custody. If you're also asking for visitation orders, mark the visitation box. Then you're going to need to put the child's name or children's names down that line, their dates of birth, and then if you're going to mark this legal custody box, and underneath here you're going to want to put the name or the petitioner or respondent that you want to have legal custody. Now, you should understand that it is almost invariably the courts will order joint legal custody. Legal custody, as you'll understand from one of my other videos, but generally speaking, legal custody is the right to make those serious decisions in a child's life, like dealing with health, education, and welfare. Like I said, most of the time that is joint. If you want to ask for it alone, the court wouldn't freak out, but you are not likely to get it unless the other parent is abusing the children or in prison or is using drugs, or there's other factors. But that was just a little background information to keep in mind. Then the next section is physical custody. And as you can see right there, it says person with whom the children lives. So that box, you can either mark joint custody. You're asking for father and mother to both have joint custody, or you can put your name in there, or you can put petitioner respondent, whatever you are, whatever you want. And like I said, you're not going to surprise the judge in this section if you ask for sole legal, sole physical custody. But, you know, it's up to you. All right. Okay, then B, the orders I request for child custody and visitation are, and then you can either attach a form that has these other custody and visitation orders in these forms, or, which I have videos on them, so you'll see those videos, or you can put as follows, and then just write in that box what orders you want. Like you want father to have every other weekend from Friday at 6 to Sunday at 6, and a dinner visit from after school until 7 p.m. on Wednesdays. You could put something like that in there. You don't need to get too detailed in there. You're going to figure that out at the hearing. But you want to put something in there explaining what it is that you want. Or you want to attach one or many of those forms that spell out specifically what it is that you want. And like I said, those forms that are all here, the 341A, D, the 312, 341C, those forms, there's videos on all of those here. All right, so now let's move on to the next section. The orders that I request are in the best interest of the children because, now put in this box why what you're asking for is in the child's best interest. So if you're saying I want dad to have, you know, every other weekend from Friday at 6 to Sunday at 6 and Wednesday dinner visits from after school until 7 p.m., in this box you want to explain why. Well, dad works like crazy. He works 60 hours. He works 60 hours a week. He's off on the weekends. So it doesn't make sense for dad to have visitation during the week, but it's in the child's best interest to have, you know, frequent visits with dad, but the most convenient time is on the weekends. And also he only works half days on Wednesdays, so he can pick up the kids after school on Wednesday and keep them until 7 or 8 o'clock at night, whatever it is. That's the kind of thing you'd want to put in there. Okay? Next section. This is a change from current orders for child custody, visitation, whatever it is. Now remember at the beginning, if you mark the change box, this is where you're going to explain that this is a change from previous existing court orders. So if you're changing the custody orders, or if you're asking the court to change custody orders, that's what you're going to mark in here, and you're going to explain that. If you're asking the court to change the support orders, actually this section is just for the custody and visitation. So if you're asking the court to change custody or visitation orders, you're going to need to mark that box. In 1, you're going to mark in there when the current orders that are already in effect were ordered, and what they were. It says the court ordered specify and what those orders are. In number 2 below, if it's a visitation plan, okay, so 1 is custody, 2 is visitation. So if there are visitation orders in place and you want to change them, you need to mark when that visitation order went into effect and what it ordered. The court wants to know what the present orders are, to determine if the new orders you're asking for are appropriate. Moving on to page 3. At the top again, petitioner, respondent, and the case number, always the same. Now, the next section, number 3, is for child support. If you are filling out this paperwork because you're going to court to ask for child support, you're going to mark that box. All right. There's just a note here. Note, an earnings assignment may be issued. C, income and withholding support, FL 195. What that is talking about is if you get a child support order, then along with that is going to come an automatic order that you are allowed to collect that money from your spouses or the father of your child, mother of your child, whoever it is. You can collect the child support from their paycheck so that when they get paid, the company sends you a check. And that's what that's about. It's just information. All right, so then A says, I request that the court order child support as follows. Again, and the next line there, that's where you're going to put the child or children's names. Okay. You're going to ask, I request support for each. They're going to do that anyway. But I request support for each child based on the child support guideline. You want to mark that box because that's the law. The law says that the state of California shall order, or that the judge shall order guideline child support unless there is some significant reason why they should be making an order for child support that is either higher than guideline or lower than guideline. And there are very special requirements and things that need to happen or be done or be found by the court before they can do that. So just ask for guideline support, especially on a temporary basis, what the judge is going to order most likely anyway. If you are asking for an amount that is different than guideline, you can mark the box to the right, monthly amount requested, and you can put a number in there that is not guideline. So if you happen to have ran the numbers and you're pretty confident that the guideline support is $900, but you're willing to take $750, you could mark that and put $750. But I'm here to tell you, you're going to have to explain to the court why you're willing to take more than the state of California is willing to order. If you're asking for, and let's say guideline support is, $900, but you're asking for $1,200, you're also going to have to explain why it is that you need more than guideline. When you get to court. So anyway, all that information needs to be in there. Now, again, if there is already a temporary order for child support in place, and you're bringing this paperwork and filing it to change that amount of money, maybe you lost your job and now you need more support. Maybe the other party got a raise and they're making more money and you want to get more child support. Those are reasons you might change. Or let's say, the other parent was given 30% timeshare, but they're only actually doing 5% timeshare. So you should be getting more child support because the children are with you more. Then that might be a reason to change child support. If it's a change that you're bringing, mark B. And then over on the right, it's asking when was the order put in place that you want to change. So when was that old order put in place? You need that date. Okay, and below that, the court-ordered child support is as follows. So in there, they want to know what the old order orders. So let's say the old order was $900 a month, and now you want to change it for whatever reason. You would put in there $900 per month. It's very, very simple. Okay. Then C is just informational. If you're asking the court for any financial orders whatsoever, if you're asking for child support, if you're asking for spousal support, if you're asking for attorney's fees, if you're asking for the other party to continue paying your car payment because you're unemployed and you need a car to take care of the kids, whatever you're asking for, if there's financial orders being requested, you must fill out an FL-150. It's an income and expense declaration. I have a video on that. You can look at that one later. But that one needs to be filed with any financial request for order. That's just what C says right there. That's all C says. Then D, again, like in the custody and visitation orders, it says the court should make or change the support orders because. So you're going to write in there why the court should make the orders. So it's kind of like a declaration. You're explaining that, the court ordered $900 a month based on, father having 30% timeshare visitation schedule, but he's only exercising 5% of the time. So the children are with me another 25% of the time. I need to feed them more. I need more electricity for them or whatever. So I need more support. That kind of thing. Whatever it is. Whatever it is that you're asking for or whatever you're doing, this is the section why you explain why you want to change the orders. If they're being changed. If you're asking for original orders and there's no present orders for child support, you leave this blank. All right, the next entire section is about spousal support. So if you're asking for spousal support, that's this section, and you're going to want to mark the box in front of 4. Okay, and again, it says that earnings assignment may be issued. And then A says amount requested. So in this section for spousal support, you're going to want to mark and you're going to want to put in there how much you're asking for per month. So if you're asking for $2,500 a month, put it in there. If you're asking for $1,000 a month, put it in there. If you're asking for $25,000 a month, whatever it is, put it in there. Okay, we stopped for just a second, so if there was a blip on the video, that's what this is about. So, but now we're on section 4B, and B says, I want the court to change or to end the court order filed on a date. So if you're asking the court to change it, mark change. If you're asking the court to end orders in spousal support, mark end. But then in that date, they're asking for what the date was that the present spousal support orders went into place, that you're asking to change or end. If there are no spousal support orders in place, you leave all these blank because you're asking for new orders. And there's nothing to change, nothing to end, and there was no date where a previous order went into effect. C, the request is to modify or change spousal or partner support after entry of judgment. I have completed and attached blah, blah, blah. So this again is changing an existing order. If you're not changing an existing order, don't mark that box. D says I have completed and filed an income and expense declaration. Again, this is warning you if you're asking for any financial orders, you must also attach an FL-150 income and expense declaration. Again, I have a video on that. Can help you work on that form. All right, E. The court should make, change, or end the support orders because. And this is where you explain very briefly why you want the orders changed or ended. If you're asking for original orders, it's very simple. You're going to explain to the court whatever the facts are. But, it might be that I am unemployed. I've been unemployed for 15 years during our marriage. The husband makes, has been the primary breadwinner, and I need him to help me support me because I don't have any income to pay for the necessities of life. Something like that would be sufficient for this form. All right. Then under property control, we are at 5. property control. This is the section I was telling you about where we could ask the court to order that you have exclusive use of your vehicle that you've been driving. Let's say you're getting divorced and you each had a car, but you had no credit, so both the cars were purchased in your husband's name or your wife's name. And that other person might be threatening, I'm going to take the car away from you because it's in my name. Well, this is where you could ask for specific orders that you have exclusive use of your car. This is a place where you could ask for exclusive use of cell phone that you've always used that might be under his account or her account or whatever. So you want to specify that here. And B says that you're asking for, say, the other party to continue making the payments on the car or the cell phone or whatever it might be, insurance, car insurance. And you can ask for that too. So you could say payment to Allstate for insurance in the amount of, $163 per month, and the due date is the first day of each month, whatever it is. The next one could be payment to Verizon or AT&T and for cell phone in the amount of $80 per month. Due date, maybe that's due on the 14th of the month, whenever it is, you're going to put that in there. So you'd fill this section out with that which, that you're asking for, whatever you're asking for. Now, C says this is a change in the current order for property control filed on. So if you're asking the court to change previous orders, that's the box to mark, and then you're going to put when the previous order was put into effect. If you're asking for original orders, and there were not any original orders in whatever it is you're asking for, then you don't mark that box, leave it blank. So specify in attachment 5D the reasons why the court should make or change the property orders, control orders. Let me show you something though. Down here in number 10, you could put your reasons in there. But I'm going to tell you something else when I get down here. But you could also take a single sheet of paper, just a lined piece of paper, and at the top of that paper, put attachment 5D. Very simple. And then either type or write on that form your reasons why the court should make or change the property control orders. So if you're asking for him to pay for your car and you need to keep the car, then that's where you explain what you're doing. All right, so let's go on to the next one. Top of page 4, attorney's fees and costs. If you are asking the court to make attorney's fees or an order for the other party to pay your costs or attorney's fees, you're going to mark that box. Next section is I request attorney's fees and costs which total, and you could put $10,000, $40,000, $5,000, whatever you're asking for. I filed the following to support my request: an income and expense declaration. You're absolutely going to need that FL-150 income and expense declaration if you mark this box, because attorney's fees and costs are a financial order. So if you're asking for any financial orders, you have to have that FL-150. And then it says, B says, another reason why you would file this request, a request for attorney's fees and costs attachment, an FL-319, or a declaration that addresses the factors covered in that form. All right, so if you're asking for attorney's fees and costs, I am going to tell you that you want to fill out an FL-319. The judge is going to expect to see it. You could do a separate declaration, but you could possibly miss some things that are required in that declaration. So just use the FL-319, and I have a video on that on this site. So look for that to help you fill out that form. Supporting declaration for attorney's fees and costs attachment, an FL-158, or a declaration that addresses the factors covered in that form. So you can either use the FL-319 or the FL-158. Look at both those forms and see which one applies to what it is that you're asking for. And then I would fill out that form. Fill out those forms, or the one that applies. Because again, the judge is going to expect to see that. Now, if there are domestic violence restraining orders in your case, and they're already in existence, mark box number 7 and give the judge the information on that restraining order. When it was issued, I request the court change or end. If you're asking the court to terminate a restraining order or stay away orders, or modify them so that the other parent can see the kids, or whatever it is, if you're asking for it to terminate or change, then mark the change or end box. And then under C, I request the court make the following changes to the restraining order, and you can put in there exactly what you want the court to, how you want the court to change them. Okay? D says I want the court to change or end the orders because. Now be careful. If you are asking a judge to terminate or change existing restraining orders, the judge is going to inquire with you, and he is going to, what we call voir dire you. He's going to ask you questions on why you are willing to do this. You need to understand that if you're asking for the judge to terminate an existing restraining order that you already have in place, or if you're asking the court to change restraining orders in some way, the judge is going to be suspect that the other party is threatening you or manipulating you into changing or terminating the restraining orders. So just understand that and be able to explain that no, this is on me. I'm doing this because of what I want to do, not because I'm being threatened or manipulated or, whatever. This is all because of what I want to do, and why I want to do it is because it's in the best interest of our kids. So anyway, that's what D is about. Or you can see off to the right, you can mark attachment 7D and again take another blank piece of paper, put attachment 7D on the top, and then explain it in more detail. Whichever you want to handle. If this is enough room right here to explain to the court, that's fine. If you want to explain more, you can do it on an attachment and call it attachment 7D. Okay? If you are asking for any other orders that aren't specifically laid out in this form, for example, the example I gave at the beginning of this video was you may be asking for emergency orders or specific orders to keep a child in Orange County or in California, or asking the court to make orders to return a child to Orange County if a parent picked a child up and just surprisingly moved to New York or moved to Cleveland or something. You might be asking other orders to return the child to Orange County. And then you're definitely going to want to do an attachment 8 and explain in great detail what's going on and why you want the kid returned. Okay. Number 9 is a request to shorten or change the amount of time that is required for serving the other party with the paperwork. If you, like it says, I urgently need, to more time to serve the other party. Let's say the hearing date is set for 40 days from now, but you know that the other party is not going to be in town until 8 days before that hearing, then you're going to want to ask the court to be able to be served no later than 5 days before the hearing or something like that, no later than 3 days before the hearing. That'll give you a few days to locate them when they get back to serve them in time. I can tell you, if you do not serve this paperwork on the other party in time, then the court is going to continue the matter for 45 days, 60 days, God knows. There's some counties where they're continuing them for 3 or 4 months if you don't get them served in time. That's the nearest court date they have. Some of our counties are poor and don't have a lot of money, so it's really hard to get court time. So you want to be able to serve the other party in time. All right, and you're going to want to look that up and make sure you're serving it appropriately. I suggest that the moment you get this paperwork filed, that you call a professional process server. They will know exactly what to do for you. That's why I'm not giving any dates, any amounts of time. I want you to do it the easy way. It's going to cost a little bit of money. It'll probably cost you $40, $35, maybe even $65. But a process server, a professional process server, has the form that's needed to proof of service. They have that form. They know how to fill it out. They know how many days they have to serve it. They know how many days early before the hearing it has to be. They know everything. So contact a professional process server. Just so you know, if you get your paperwork filed and you serve it in the next couple days, anybody but you that's an adult that lives in California can serve this paperwork. So your cousin, your brother, your nephew, a coworker, your mother, father, anybody can serve the paperwork on the other side. It's just, I recommend using a professional so that you know that it gets done correctly. Again, remember, you cannot serve the other party. All right, so the number 9 section is if you're asking for a shortened period of time to serve them. You're probably not going to need it anyway, so all that information was probably moot. All right, then number 10. 10's a big deal. 10 is where you do your declaration. This is where you give the judge all the information that you believe the judge needs to know to give you the orders you're asking for. We typically call that a declaration. So, if you're asking for child support, custody, visitation, attorney's fees, maybe, property rights, to use the phone, to use the car, and have the other party paid, you're not going to have enough room in 6 lines to explain all of that and all the background information of why you're asking for it and why it's in the child's best interest in that space. It's not going to have enough room. So you can either take another blank piece of paper out and entitle at the top attachment 10, or I have another video that is on a declaration, and I recommend using that declaration format, and you can download it here, and use that declaration format to do your declaration. That way you can type it, you can take your time and come back to it and change things if need be, because you need to understand that the declaration, almost invariably, the declaration is the most important, in my humble opinion. I've been doing this for 20 years. The declaration is the most important piece of paper you're going to give to the judge. Why? Because most judges, we like to think, we know it's not true for all judges, but most judges read the paperwork in their chambers before they come into court, or they read it the night before, or whatever. They read your case. They read the moving papers, and they read the responsive papers. And I'm here to tell you, if your declaration is written out and explains what you're asking for, what kind of custody orders you're asking for, what kind of child support orders you're asking for, and your declaration explains why, and it gives good reasoning, and it's written in a manner that explains that this is in the best interest of the child, and you're putting in there the good, bad, and ugly about the other party, and you really explain what's going on, I'm here to tell you the judge is probably 80–90% of the way of making their decision up of what they're going to do and what they're going to order in your case before they hit the bench. And I'll bet you most judges would deny that. But I've been doing it long enough to know it's true. And I've heard judges tell me this word of mouth, that they read this stuff and they get a very good idea of what's going on in this. If the declarations are complete, they get a good idea of what's going on in the party's world. And they get feelings and thoughts, and they know what their concerns are and what makes them happy, what makes them upset in this declaration. And then when they come out to the bench, you will invariably have considerably less time to change the judge's mind at court than your opportunity to, have the judge think and feel the way you want them to feel through your declaration. So take the declaration very seriously and do a separate declaration. I recommend that you use my format that I have in another video. Use that format and really do a good, solid declaration. You should know that a declaration is limited to 10 pages, but this is important. If you give the judge 10 pages of typed information, I would be astonished if the judge read all of that. There are some judges out there that read every single word, no doubt about it, but it is my firm belief that most do not. So 2, 3, 4 pages, really give them the meat of what you need them to know. And, they don't need anything superfluous. You don't need any of the extra stuff that's not necessary. But that which is necessary, make sure you give it to them. Make sure you give the judge the information that you need. Okay, so that's the declaration. That's the FL 300. Again, like I said, it's the form you're going to use when you're asking for almost anything. If it's not child support, custody, visitation, attorney's fees, spousal support, those boxes that are already on this form, then it's going to be under other orders requested, number 9. On 8. And then you're going to explain that in an attachment or right here on the form. All right, folks, when you get done with this form, you're going to put your date on the bottom that you sign it. You're going to handwrite your name to the left or type it. And then on the right, next to the right, the black arrow there, you're going to sign it. And then you file it with the court, along with whatever other forms you're going to use. You may need your FL 150 if there's financial orders, we talked about a few times. You may have custody orders. You may be asking for holiday schedule with a custody and visitation order. That's a 341E. Yeah, there's other forms that you may be attaching to this to go along with your requests. If so, you're going to attach everything, including that declaration that we were talking about. That all gets attached to this and filed with the court. Again, remember, anytime you're filing something with the court, bring 2 extra duplicate copies. The originals and 2 copies, because they're going to stamp the other ones as filed. And then you've got proof it was filed. You have a copy of exactly what you filed. You're going to have to serve the other side with one of them. You need copies. All right, folks. Again, my name is Doug Pinkham with Pinkham & Associates, dedicated family law firm in Orange County. I hope this video has been helpful for you. Thank you for listening.